Hello, everyone, and happy Friday. I am attorney Jephonne Roy from the Farrell firm. Here at the firm, we focus a lot on the practice of family law, which covers divorce, child support, legitimation, guardianships, adoptions, etc. You can go and check out our website to find out more about the firm and learn about the awesome team that we have on staff here. Today we're going to be freestyling and doing things a little different. We're going to do a live Q&A, and so I won't be talking about anything particular, but I'll be answering your questions if at all possible. You can also check us out at our Facebook page to stay up to date with us and receive notifications about events and live chats that we have going on. So now, like I said, today we're going to be answering questions. I'm going to do a live Q&A. We've been going live on Facebook each week since May. Each time we are live, we try to answer every question that is posted. However, a lot of people miss the live video and end up posting their questions later or sending us a message with their question. Today, I won't be covering any particular topic of family law, but I'm just going to chat with you and answer whatever questions you may have. And I will start with some questions we have gotten in our inbox. Before we get going, let me give a brief disclaimer. By tuning in today and participating in the answers and questions session, you agree and understand that we are not creating an attorney-client relationship. You also agree and understand that no conflicts of interest are being created in the event your ex hires us before you do. So let's get started with some of the questions we have been receiving in our office. My daughter starts pre-K in August. Can I pay less child support since there is no daycare? So the question, when child support was entered, your daughter was likely in daycare full time. And so there is a possibility that you can modify your child support because you no longer have the full-time daycare expense. However, keep in mind that if your child needs before and after school care, you'll have to take those costs into consideration. So you might want to determine if it's worthwhile going through a modification of child support or leaving it as is and having that amount for before and after school care coming out of the child support. In other words, you want to make sure that if there's no agreement to modify it, that it'll be worth your money to seek representation to do so. All right, our next question, it says, my wife and I adopted her nephew and now we are divorcing. Am I on the hook for support? Yes. When two people adopt a child, they adopt them as wife and husband or mom and dad. And so just like any other parent, you are legally and financially responsible for that adopted child because now under the law, you are that child's father. The adoptive father nonetheless, but you are still on the hook for their financial support. Same thing would go for mom. If the nephew came to live with you or you were awarded custody of the nephew, then mom will be paying you child support. Next question says, I am not allowed to visit with my children and I pay child support. What can I do? Well, the first thing you want to do is if your child was born out of wedlock, then you want to legitimate that child or children so that you can establish your custodial rights and a visitation schedule. Child support is a right that each parent who has a child has a right to collect, even if the child is illegitimate. So if you don't have any custodial rights or any visitation schedules, then legitimation is the best route to go. Now, if you were married when your child was conceived or born and you have an order that gives you a certain time to see your children, then you would need to file an action for contempt since mom is not complying with that order. That would be the best route for you to do. The next question says, I already have a court order, but my ex will not follow it at all. Should I file a police report? Police reports are not as helpful as filing an action for contempt, either in the court that issued the order or where the defendant resides now. And if it's an out-of-state order, there are a lot of steps that you have to go through to get that order domesticated. But generally speaking, for Georgia, if there's an order that's not being followed, the best route is to file an action for contempt. The next question asks, I don't know where my husband is, so how can I divorce him? So if you don't know where your spouse is, you have no idea where they are, you cannot find them, you can get a divorce by publication. That means you run an ad in a paper for a certain number of weeks. They have a certain number of days to file a response and answer. And if they do not, the court will issue a divorce. What cannot happen by publication is any child support or custody determinations unless the child lives with you already. And that's for custody. So if you file for divorce and your child is living with you, the court can award you primary physical custody, but they will not be able to address child support because they don't know where mom or dad is and they have to have jurisdiction over that person. Next question says, I lost my job and can't afford child support. Can I modify it to my unemployed income? That is a great question. We get that question a lot. And the answer is, it depends. So if you lost your job, you were fired or laid off, they can modify your child support based on your unemployment wages. However, they can also keep your child support where it is based on your earning history and your earning potential. So if you got laid off from a job and you were making $85,000 and you go to modify your child support action, they could keep your child support at the $85,000 because what it says is that you have the potential to earn that money. Now, if there has been a diligent effort to find work and you have not been able to find work and you have proof that you've been looking and looking diligently, not just applying for anything 30,000 or 10,000 or anything like that, then there is a possibility that the court could lower your child support and base it on your unemployment. But that is not a guarantee. And the last question that we have that we've already had was, I'm a stay-at-home mom. My husband said he is filing for divorce. I should get alimony, right? Well, alimony requires two things. It requires the need and the ability to pay. And so if there is a need for alimony, meaning you've been a stay-at-home mom for 20 years, you've never held a job, you don't have a formal education, then there's a possibility that you could be awarded some alimony. However, in my opinion, alimony is a dying breed. And so it's not as often awarded as people would think. And so it's kind of hard to get alimony if you're able-bodied, you're able to work, you're able to go get training, or you're able to go get a job. Alimony is just not something that's being handed out these days. Now, it's in each case, each circumstance is different. So it does depend on your facts. But alimony can be awarded. It just has to meet those two requirements. Okay, I'm ready to take some questions from our viewers. Hannah says, what is the other party is not following the order? What can I do? Can I get the police involved? So if you have a visitation schedule and the other parent is not releasing the child, you can call the police and ask the police to help you get your child. And if they read the court order, most of the time they will help you to enforce that court order. But again, the best route to take is to file an action for contempt after you've made the attempt to retrieve your child with the help of the police. It says, is it true that child support is on 20% of my income? That is not true. Child support is based on the gross income of both parents. Back in 2007, or before July 1st of 2007, the law based child support on the non-custodial parent's income, and it was based on a percentage and the number of children. That is not the case for today. Today, the child support guidelines use the gross income of both parents, and that information is put into the child support worksheet. along with some other things that are expenses for the children, healthcare premiums, and things like that. And that is what determines child support. Next question. How can I receive owed child support if child's father lives out of state? So if that order for child support was issued in Georgia, then you can file an action for contempt in the court where it was issued. In other words, if you have an order from Georgia out of DeKalb County, you can file a contempt in DeKalb County, have the father served in the state that he lives in, and bring him back to Georgia to answer for the non-payment. And that's one route that you can collect child support that is owed to you. Another route is to use child support services and have them enforce the court order that you have, and you can do that by going through child support services. What is the other party is not, oh, I think we already answered that question. I apologize. The next question says, can a grandmother get custody of the child if the parents are married and going through a divorce just because she thinks the father is not capable of care? No. Grandparents have been given some rights here in the recent months, and part of those rights is what they call grandparent visitation. But that is a high bar for the grandparent to get visitation or get custody over a biological parent. And there has to be extenuating circumstances that would warrant a grandmother or a grandfather to be awarded custody just because the parents are divorcing. And because they don't think dad is capable of caring for the child or children is not a valid reason. The next question says, if me and my wife are in the process of getting a divorce and my wife decides to leave the house and take the TV and other items from the house with her, what can I do? What can I do? The cop said I have to get the judge to deal with them, and they can't. If you're in the middle of a divorce and your wife is taking things out of the house, I would advise you to handle those things within the divorce, meaning you can ask the judge to compensate you for what she's taking, because everything that you've acquired during the marriage is marital. And as such, there really shouldn't be anyone moving any items from the marital home until there's a final order in place that decides what goes where and what goes to who. And so if your wife is taking things prematurely, then you might want to address those things at a temporary hearing or a final hearing, and the judge will make a decision about how they will address that issue. Next question, can CSS refuse the modification? If I'm reading your question right and I understand it, that means, can child support services refuse the modification? They only do modifications every 3 years unless there is a large increase or decrease in income. And by refusing to do a modification, I'm not sure I understand that question, but they only do it every 3 years with child support services. However, if you want to modify child support because you know they've gotten a raise or you've lost your job or something of that nature, with a private attorney, you can do that at any time with certain situations, like a large increase in income or a decrease. And privately, you can modify child support every 2 years versus every 3 years with child support services. Okay, so right now I don't have any questions. I'm going to give you all a few minutes to ask any other questions that you might have before I sign off. I hope that the information that we provide is helpful, and we enjoy doing this every week here at the Farrell Firm. We look forward to servicing your legal needs. They keep saying I can't because I have a new caseworker. It starts over. Well, I'm not familiar with child support services ins and outs. What I do know is that you can modify a child support order every 3 years. I don't know if they're having an internal issue with the new caseworker or how that plays a role. But if you have a court order for child support, you use child support services to enforce that court order or to establish a court order, and then you follow their rules and guidelines to have the order enforced. Next question, it says, what if the child support order was for 3 children, but 2 of them are now in college? Can I just stop paying the full amount and just pay for one without going back to court? No. You have to modify your child support order through another court order. Otherwise, you're going to be on the hook for the full amount of child support. So it's always best to go the right route versus going the fix it yourself route. If you fix it yourself, you're really creating a mess for yourself and you'll have to deal with it in the long run. So you always want to modify child support through the system so that you have a modified court order and you're not on the hook for the old court order. And Ms. Lamarcy, you're asking for our contact information. I will give it to you. Our office number is 678-973-2803. And you can also go to our website and get our information at farrellfirm.com. Next question is from Mr. Lawrence. Is it beneficial to file for a legal separation before filing for a divorce? That is an excellent question. And actually, the only difference between a legal separation and a divorce is that at the end of those processes, one of them you completely sever ties, and that's the divorce. The legal separation, at the end of all of your assets being distributed, divided, people being awarded custody and child support, at the end of that road, you're still married. And if you want to get divorced, you would start that process all over again. So unless there are, I can't really think of a reason to do a legal separation versus a divorce, unless you just want to have something on paper to give you some time to work on your marriage. That would be the only reason that I could see that a legal separation would be plausible. Okay, I'm going to give you guys a few more minutes to ask questions. Today is our live Q&A. I'm not talking about anything particular to family law, but I'm opening the floor up to you so that you can ask any questions that you have, and I'll be glad to answer them. Another question says, can I stay on my spouse's insurance after a divorce? You can if your spouse agrees to keep you on there, but the judge cannot order that they keep you on there. So if you guys have an agreement where they want to keep you on their insurance, that's between you two, but a judge cannot order them to keep you on their health insurance. Next question is from Ms. Lauren. It says, if joint custody was granted, can you modify the agreement to full custody to include child support? Is there a time limit? There is no time limit to a modification. You can file that at any time. And if there is an agreement, then you can avoid the litigation process altogether and just do a final consent order to include the child support. If there's no agreement, then you have to go through the litigation process, file the modification for custody, visitation, and child support. And at the end of that process, you'll have a different order than what you have now. Can dogs be put in a court order after a divorce? Yes, a court will decide where the pets or the family pets go if the parties cannot agree. So we've had instances where couples have come in or someone has come into the office after they have a final divorce decree and they're distraught because they have 3 dogs. One party wanted 2, the other party wanted 1, and it was never discussed. It was never brought up. And while judges don't want to have to tell you where your pet should go, they will because it's marital. Can my spouse be required to pay child support for my child once my child is in college? Can we put anything about college in our settlement agreement? So that's a 2-part question. The first part of that question is no. Child support ends at 18 or upon the graduation of high school up to the age of 20. And if your child is 19 and still in high school, then you're still obligated to pay child support. If you agree to pay college in your divorce or with your other parent and you guys come to an agreement, you write it up and there is a formal agreement that was included in your divorce decree, then they could be on the hook for college expenses, not under the basis of family law per se, but under the contract of the settlement agreement. And so it would be like an enforceable contract. Can I change the locks on my house if my wife already moved out and gave me the key back? No. So you cannot change the locks on your house just because she moved out. She's still entitled to be there or come there. You cannot evict your spouse. You have to wait until there is a court order giving you either awarding you the home or giving you exclusive use and possession of the home. So although she moved out, she gave you the key back, she's still your wife. She is still entitled to come to the house. What if she breaks into the house because she does not have the key? Well, what will likely happen is you'll call the police and say, hey, my wife broke into the house. She will say, I broke in because I didn't have my key. And likely nothing will happen because she is your wife. You guys did live there together and there is no court order that gives you exclusive use and possession of the house. Okay, I'm going to wait a few more minutes for any other questions. You're welcome, Mr. Oscar Delroy. All right, I don't see any other questions coming in, so I'm going to wrap up this session of our live Q&A. I hope you have enjoyed it, and I've answered every question that I saw or seen come through, so I look forward to hearing from you all. Oh, I got one more that just came in. It says, will IRS automatically get involved with owed child support? Well, the IRS will not get involved with anyone that owes anyone child support. It can go on your credit report, though, but I don't know that the IRS will intervene with child support issues other than if there's a problem with the tax return or someone claiming a dependent that they should not have claimed. The next question says, I haven't seen my daughter since November. My daughter is 8 and very disrespectful since her mom is allowing it. I'm not sure if your daughter is legitimated yet or if you were married to mom when your daughter was conceived or born. But if you don't have her legitimated, if she was born out of wedlock, then you need to go through the legitimation process. And you can go to our Facebook page. We did a whole session about legitimation. And so I would advise you to start there, get the information and see how you want to proceed. And part of you countering what the mother will allow is actually being an active dad and trying to change her behavior because you have an influence on her as well. Right now, it seems like mom has all of the influence because you haven't seen her. So I would go through the proper legal channels to get something as a court order so that you cannot be denied. She is legitimated, but I haven't living up to my end of what can I do? I'm not sure I understand. So what do you mean you're not paying child support right now, or you have not been exercising visitation? I'm kind of lost with that question. Give me some clarity and I'll try to guide you as best I can. So again, this was our live Q&A here at the Farrell firm. I hope you all have enjoyed it. I'm getting ready to wrap it up. Let's see. Okay, so child support and visitation are separate issues, Mr. Marley. Although you may be behind on child support, that does not mean that you don't get to exercise your visitation. Now, if you can't exercise your visitation because you're not stable enough yet, my best advice is to get stable so that you can exercise your visitation. But if you have a court order that gives you visitation and you don't have your own place, or you're living somewhere else or with someone else, you can still exercise the visitation in your court order as long as you have your daughter in a safe place. And so a lot of people think if they have a roommate or if they're living with their parents or one of their friends, they cannot exercise their visitation. But as long as your daughter has somewhere safe to be with dad, she has her own bed to sleep in, then you should be exercising your visitation. If not your complete weekend, then, at least partial, do something so you can have constant contact with your daughter and try to build that relationship up. Again, child support is a separate issue from visitation. Even if you are behind on child support or never paid child support, that does not mean that you do not get to see your children. It means you're in contempt of court, but it doesn't mean that you don't get to see your kids. My kid's mother has not given me any financial support since May 12, 2017. She is the primary custodial parent and we share joint legal custody. However, the kids have been with me since October 2016. I filed a modification for custody support yesterday. Can I seek back pay on child support? No. No, you cannot. So child support is not something that you can seek retroactively here in Georgia. And it's quite the opposite. You'll have to defend why you haven't been paying child support since October 2016 if you actually stopped. And if you didn't stop, I commend you for that. But I'm glad to see that you filed a modification of custody and support yesterday. The next step for you is making sure that she gets served properly by the sheriff or a private process server, and then you can move forward with your litigation process. All right, any last minute questions for me before I log off? Okay, I would like to thank you all for tuning in. Thank you for your awesome questions. They were really good. I appreciate it. I hope that we were helpful to you today. Again, our website is farrellfirm.com. And Mr. Hawkins, I understand that. But if there is a court order for you to pay mom child support and you have not modified that, let's say when they started living with you in October 2016, you are still on the hook technically for the support that you owe her. However, a judge can give you credit for that child support since they have been living with you since that time. That's just something that you'll have to litigate in court about. This is a question that I was answering. I forgot to put it up for you all. In any event, I am going to be logging out, and we will see you all next week. Thank you for tuning in.